This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
It's kind of sticking into her hair. That sounds awful. That's got the whole punchy nose. Yeah. Just choke. You're out right.
Hi everyone, I'm Rob, I'm from MUPS. Just letting you all know that MUPS is going to be organising bulk printing of the Planning and Environment Act for the exam, so you don't have to go and spend $50 at the library printing that yourself. It'll be $25, so it's still half the price of doing it yourself. There'll be a link to a Google form for ordering that'll go up on the MUPS Facebook page and the group page, and Alan has agreed he'll send out an email with it as well. The process is pretty simple, just need to transfer the payment to the MUPS bank account. The details for that will be with all the other forms and everything. And make sure you include your name in the payment description so that we know who has paid and who can pick up a copy of the Act. So order by Friday the 11th of May, which is week 10, and it'll be ready for week 12.
Great, woohoo! Wonderful, go MUPS. Okay, I have a really croaky voice because I've just given about 8 hours straight of lecture, so I might just compress what I say a little bit tonight because I feel like my voice is starting to fail. So, today we have the second part of VCAT appeals, and I would also like to talk a little bit about clause 58 of the VPPs. So I'll fit both in. I will not go to the actual cases and VCAT appeals that we describe in here. I was trying to do it earlier and I had a little computer error, operator error, I think. I couldn't seem to save the appeals as relevant. But through this talk, there are a few appeals referred to, and I will save them onto LMS. If I'm a bit slow doing it in the next couple of days, feel free to go and find them yourself anyway. There's nothing to stop you doing that. But it would be good for you to follow the line of argument expressed in the lecture with actually looking at the VCAT determinations. So this will be a little bit on the dry side, he said, holding water. But what we will do from next week is to start following through and looking directly at VCAT cases and getting you to look at the cases prior to the lecture, and we'll have a discussion here and maybe a discussion in the tute groups as well. So we'll sort of change the pace a little bit. So hopefully this is the last of the relatively dry kind of information transfer approaches that we have. So there are a number of ways that you can arrive at the tribunal, at VCAT, and it is worth knowing relatively thoroughly some of the more common mechanisms by which you can arrive at VCAT. That might be a bit easier to see. Okay. Many of them have two components to them. So section 52 is the part of the Act that talks about giving notice about the potential for detriment, and section 78, which I will go to now, takes you to the part of the Act that describes your rights of appeal in this case. So we'll just have a little bit of a look at that. I'm not just doing this to give my voice a rest. Victoria, and then we go to that, to the current acts. Planning and Environment Act, 1987. Okay, so what we're looking at, we're looking at 52. So let's just examine that very briefly. Is that feedback right here? Okay, so I won't go through the whole thing, but of course section 52 is about giving notice, depending on who does that, that there is the potential for detriment to be suffered by anybody. If we just go back here, we look at section 78 of the Act. We go back to that. Oh, this mouse is fighting me. It sets out here applications for review of requirements. An applicant for a permit may apply to the tribunal for a review of a requirement by the RA to give notice, or a requirement by the RA for more information under section 54. So if you felt as an applicant that it was excessive in some way, you might want to go down the path of appealing that particular process. An example might be, say, under section 54, that it's a relatively minor application. You feel that maybe the cost of preparing all the documentation, the drawings, the reports, is excessive, that they're asking under section 54. So come on, it's just a little extension out the back of an existing house. Do we really need an urban design report? Does it really say that in the planning scheme? What makes this so special? I suppose if you took exception to that, you could appeal it under section 54. So most of the time these aren't being used, but in some cases they are. So again, just affirming that if you go through and you look at the Act, you will find lots of these little things that are there potentially to be used, essentially to make things fair most of the time, to keep things in check. So there's review of requirement for further information, and similarly, review of refusal to extend time to provide further information. So I'll let you guys speak. What is that one about? So section 54 is about further information. Who's asking whom? That's right. So why would there be this review of refusal to extend time to provide further information? At a guess, you know. Yeah, I think that's quite a reasonable answer. So some things will actually take quite a bit of time to prepare. You might not have the money, it might just be a very complex task, you might be away, and it is not uncommon to request further time. Now, remembering what happens if you don't respond with further information within the time set out in the regulation. What happens to your application? It's abandoned, it's over. So it could potentially be a rather important matter for your application to be considered abandoned, for it to cease. So if you felt that that was really significant, you do have a right to apply for review on that matter. And I suppose, town planning kind of covers many different aspects of very minor things up to absolutely massive matters with all kinds of values associated with them, and indeed financial matters as well. So potentially a lot riding on some of these cases. And you're probably reasonably familiar with these appeal rights now. Section 77 is about refusal to grant a permit. 79 against failure to grant a permit within the 60-day time limit. 76C and 77, review of a decision to refuse to amend a planning permit. Section 80, appeals against conditions on a permit. And 149, review of decision to refuse to grant secondary consent. So there might be a need to change what's in a permit, an existing permit, for example. So let's think about merits reviews and objectors. Section 82 says that an objector may apply for a review of decision of the RA to grant a permit, or indeed to issue an NOD. The objections must be received by the RA and be in writing with a name and an address, some sort of contact details. In section 82B, any person may seek leave to apply for a review of decision to grant a permit in any case in which a written objection was received by the RA. So remembering that if you haven't lodged an objection, you may well be in a situation where you have no rights of review. This, again, could have quite significant implications because once you've lost your right of appeal, you have no more voice and you might suffer considerable amounts of detriment or inconvenience, whether it's the architectural style through to noise next door, whatever it might be, traffic and parking, you name it. And some of the other cases that can occur in the planning list of VCAT relate to declarations and enforcements. And so, as I said last time, a declaration is when there's a case, an application or a potential application where it is not clear how to interpret something. Some sort of meaning is not understood properly. It might be prior to an application or it might be during a process that is being determined. So I'll show you an example of that in a moment. And issues of law, who gets to make decisions, how definitions are understood, and so forth. Enforcement is about stopping people doing things, or sometimes making them restore them. But if, for example, someone has commenced demolition or has started using land for a purpose that they don't have a permit for, the council, or indeed any member of the public, can seek that enforcement action is taken by VCAT to stop them doing it. And you might recall I described the Corkman Hotel next to the Law Building where demolition occurred illegally, and they're seeking to get the restitution to have the old property sort of reproduced in that case. So I won't go through all of these in slavish detail, but rather you just need to know that they exist and the general function of these sections in the Act. And in an exam, to give you a sense, I might ask you what bit of the Act would a declaration for a certain matter, what bit of Act or which sections would you use to bring about certain outcomes about a matter where you needed legal clarification, for example. So I won't be too mysterious about it. I just want to see that you know that it exists and that you can interpret the words of the Act. So, material detriment. So this question under section 52, it has often been a somewhat vexed matter what it is that would actually count as material detriment. And so one thing that the tribunal does provide for us is an ongoing update of current knowledge. And if you go to McBride versus Stonington, you will see that Helen Gibson, the Deputy President, very esteemed town planner, has presided over a tribunal hearing, and she sets out some principles that still stand about what might be material detriment. So the words material detriment are in the Act, and Helen, or Member Gibson, I should probably say, has said the detriment referred to need not be substantial. It must be real as distinct from being fanciful, but it may in fact be only minor. However, the fact remains that what section 52(1)(d) is talking about is detriment, which means loss, damage or injury. It is not simply talking about an effect. Any development proposal will have an effect of some sort, but it is only if it will cause a real detriment, albeit only minor, that notice will be required under section 52(1)(d). If a benefit will be caused, as in the present case by lessening the current potential, then notice would not be required. So it's saying some things might in fact have a beneficial effect, and we would not require notice in that case. So if I wanted to read more about that, what would I do? Look, that's not working. I would probably go there, and you can simply do this. It probably won't work now I've done that, but if you go into Austlii, I'm just doing this so you see it done. And when was that? 2005. So if I'll start up a new Austlii. Gravity has a pull that this lecture theatre seems to enhance, doesn't it? Lost pens and water bottles. So we're in Victoria, and if we go to the tribunal post-1998, and then we go down and we find the planning and environment list down here, and you have a search bar there, and it's actually an incredibly powerful tool to be able to go back over all of these. Oh, it didn't work, did it? Wonder why. That should work. There's something spelt wrong. I was speaking with such I was so enamoured with the process. It's so disappointing. Let's get rid of that. It might work. Why did it put it back? It's probably a spelling error that I've made. Let's have a look. McBride, Stonington. Getting the right number of N's in Stonington is a challenge for me. The other thing you can do is this. And if this doesn't work, I'll have to quietly downplay my slight sense of embarrassment at the process not working. I'll do that, and I'll put that in. McBride versus Stonington. Well, I don't know why that didn't work. Sometimes mixing things can go a bit wrong. But, okay, so you'll see here that VCAT gives things numbers. It uses a single V for verses. It tells you which list it is in. And it sets out who the different parties are, the responsible authority, the land, who the member was or members, and the dates on which things occur. And when we go down a bit more, you'll see that there's a few things going on here, but demolition and other matters were part of it. But here, Deputy President Gibson has set out some facts and interpretations of this question of what is detriment under section 52(1). And what we have now, over 40 years or so of hearings in various formats, is a huge database of careful interpretation of the Act. Obviously it's been amended over time, and of planning schemes as they've been amended. So a common thing to do is, if you do find that there is something that is a little bit uncertain, you may find that going looking for in those searchable things, that search box in the VCAT hearings, you may find that someone has gone to the trouble to actually define or make clear a point of contention or uncertainty. So, as I said, a huge database of information there. Okay. What happens if no advertising is required? Well, we simply don't advertise it. I've been asked that. But we need to advertise. No, you don't need to advertise if there's no potential for material detriment. Yeah, that's it. Okay, so referral authorities. What part of the planning scheme sets out who are referral authorities? Anyone know? Starts with a 6. Okay, we'll go over here. Let's look at Moreland. And we'll go down to the ordinance and we'll look at 62 or 66, depending what we're looking at. And it's taking a very long time. Where's 66 gone? 66.0, okay, 66.04. So let's just start at the top. Subdivision referrals, that'll do. So the planning scheme sets out, and largely these are just set in the VPPs, as in they apply the same everywhere across the state, and it sets out certain parties to whom referrals must be made for certain types of application. So obviously here we're under subdivision, as in when we modify property boundaries through the planning permit process. And you can see, there's an example, I've been working on this stuff today, to subdivide land outside the Metropolitan Fire District, which creates a road, we must be in touch with the Country Fire Authority in case it has an impact on the risks associated with bushfire. And in fact, sometimes you might find there are a number of different agencies to whom notice must be given. So to subdivide land crossed by a gas pipeline, the relevant gas supply authority. So this is sometimes quite an onerous element of the planning system, but it's there for a very good reason, which is to seek to integrate and coordinate activity so that we don't have contradictions, sometimes very gross contradictions, where, say, we couldn't maintain the integrity of the gas supply system because someone's gone to subdivide land and it causes problems with the gas supply lines, etc. So if you have a look through 6601, you'll see there's quite a lot of referrals potentially for many things. It's not just subdivision, it's use and development and various other things. But you'll look here on the side, it says type of referral authority. And these ones each say determining, and, oh, hang on, they're all determining. And the other one that you can get is, hang on guys, I'm going blind as a bat, use and development. So we've got determining, and then we've got recommending. What do you think the difference is?
You have to listen to a determining authority, but recommending is just...
Bang on. Bang on. So the responsible authority is sending the application to these named entities, Secretary of Development of blah, 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 and they make a recommendation in this case. the application comes back, or that recommendation comes back, but the responsible authority may choose to ignore it. However, if it is a determining authority, they must follow that. So there are many cases where Vic Roads, Country Fire Authority, you name it, they are the actual determining authority. And they do that on the basis of representing their own interests. So that can potentially be quite a powerful element of the process. So you can see here, an RA cannot issue a permit if a determining referral authority objects. It must insert any condition requested, and in addition, there might be conditions listed by the planning scheme. However, an RA may determine not to issue a permit if a recommending referral authority objects, and it may insert any conditions. So that doesn't mean they won't necessarily make a decision about other matters. So an example might be use and development for a shop on a main road. It gets referred off to Vic Roads, and Vic Roads says, yep, that's okay, we don't mind, but the responsible authority may still refuse it on other grounds, of course, because they've got to satisfy everything. It's not just on one matter. Okay. Permits that are issued by council or at the direction of tribunal sometimes need to be amended. I mentioned very briefly the Wade case maybe 2 weeks ago. If you want to search that case, it is Thorpe, Thorpe versus Wade. We call it the Wade case because it's quite a famous case. It's a complex one, but it went to the Supreme Court. Basically, it turns upon, there's a lot in it actually, it's like, I don't know, it might be 35 or 40 pages, probably depends exactly how you print it, but Wade was a famous footballer in the mid-70s. I'm from the country in WA. I didn't know he was famous, but I was quickly told that when I was referring to the Wade case. But the case was essentially, can you modify a permit, or do you need to go to the Supreme Court? And this case triggered that we would have a different set of systems so we could modify permits and resolve problems or inconsistencies without going to all the trouble of going to the Supreme Court to do that. So that one is searchable online, but because it's in the Supreme Court, you have to make sure you search for it not in the VCAT cases, but in Supreme Court reports. Okay, enforcement. If someone has breached the planning scheme, what would be the first step? Well, there's probably a number of steps here, but the first thing you do is just get in touch with them and let them know they are breaching the planning scheme and ask them to stop. Because oftentimes people simply don't know and will quite happily do so. But if it requires more than nature, as in they refuse to stop or it's not convenient for them, if you recall back a few steps here, we had all of those different mechanisms through different parts of the Act to take enforcement action. So, to make this fun, I think we will read this, Mornington Peninsula versus Tuscan Enterprises, for next week, and we'll discuss that at the start of the lecture, because that will be fun. Okay? Don't say I don't make you have fun. Okay? Usually in the tribunal, each party bears its own costs, but sometimes in enforcement matters it may impose costs on some parties because they have kind of broken the rules, so to speak, and they're kind of costing everyone else money, the tribunal and any other affected parties. And sometimes we go into a different process largely through, well, ends up in the magistrates' court, where a prosecution can actually be brought against a party for not complying with the planning scheme. Generally speaking, these are people who are kind of knowingly doing it on purpose for their own gain rather than making an honest mistake. And one of the ways to start that process, well, normally we'd put in an interim enforcement order. If they didn't comply with that, then we'd take it further and it would become, in a sense, a civil matter rather than a tribunal matter. So I won't go into this in great detail. We won't examine this in huge detail in the exam, but again, we would like to know that you were aware that this process exists and you should know some of the key sections of the Act that deal with it. The proof is beyond reasonable doubt, or the balance of probabilities. So that means you do need a higher level of evidence than in a normal tribunal hearing. But also it means that if you are wrong or misleading, you could have action taken against you by the court itself. So we're getting into the territory of, you know, the real law here, so to speak, rather than the tribunal, which is kind of soft. Okay, the penalties can be quite high, but in fact, if you think of some of the cases that have happened recently, like the Corkman Hotel, this is in fact quite a small amount compared to the, and that's the maximum, that's actually quite a small amount compared to the real cost that those guys incurred by knocking down an important heritage building. So I think it's fair to say the Planning Act and the regulations are fairly soft in terms of enforcement of planning matters, unfortunately. I think I'll leave all that. That's fairly clear. Okay, declarations. Now, as I said, these are to clarify matters, and we'll just have a look here. And I want to remind myself what the case was. Declaration is under section 149A, and it might be interpretation, defining existing use rights, etc. And you apply under section 149B. Generally speaking, they're dealt with fairly quickly because it might be to facilitate keeping a process running, and sometimes they might be done very quickly as well. Now, this is the one I wanted to search up. So, Corangamite, this is the last one. And if you have a look in here, you will see are we in the planning list? Yes, we are. Oh, there'll be heaps of Corangamites. I looked at this last night. I don't know why it's not making it easy for me. It could be that it's dragging with it little hidden symbols or something. Control C. Yeah, Corangamite is very common, so I'll have one more go. Good idea. It might. Yeah. So what word do you reckon? Maybe just the number might be enough. Oh, it's auto-filling now. One more try and I'll give it up. I say that now. Stop that. Maybe you've got to have... I reckon you're right. How many did I get there? Oh. Dave, but we're getting there. Okay, so it is the correct one. Oh, there's a few of these. Okay. Okay, so this is an interesting one, and I suggest that we also look at this one first thing next week, because this was a case where there was it's ongoing questioning of the declaration. So it's got a little bit of spice to it. Also, I have a particular interest in heliports. And I'll admit to you, it's based on one of my earlier mistakes. I advised a client back in 1998 that they didn't need a permit for a heliport, which was true that week, but then they changed the rules the week following and they did need a permit. So then the client was unhappy with me because I should have known, and we had to subsequently apply for a permit for a heliport. It was all fine, but it's a good reminder that you should always check kind of every time, particularly because we keep changing the planning system again and again. In my defence, we didn't have the internet. We had to go and look at the paper copy, so we did rely on our memory a bit more. But anyway, there were a few matters here, but when you read this, look at how the declaration was sought to understand what is a heliport and what is an airport, and do they need a permit for it, and do they already have a permit for it, which would have been quite convenient for them, and so on and so forth. So small matter, it's a really quick one to read, but you'll see that there's a history of these, as in I think there were two other ones before this that will explain the whole thing. On the other thing, do they have existing use rights? As in, because they already had a permit for flights on the land. So does that include a heliport? So, have a read, see how you go with that. All right, I propose a short break, and then we will have a look at clause 58. Okay? So if you're back by 5 past. Cold. Is it cold in here?